This is a Legal Resources for the Elderly Program presentation. This presentation is based on New Mexico law and is intended for informational purposes only. Because every individual's situation or problem is unique, you should always seek advice of a qualified attorney for assistance with your individual concerns and questions. Hello. My name is Natalie, and I am one of the staff attorneys at Legal Resources for the Elderly Program. In today's video, we will be covering your Advanced Healthcare Directive. First, a bit about our program. Legal Resources for the Elderly Program is a joint project of New Mexico's Aging and Long-Term Services Department and the State Bar of New Mexico's State Bar Foundation. Our program offers a free statewide legal helpline for New Mexico seniors age 55 and older. Our attorneys advise on a variety of civil legal issues, such as powers of attorney, estate planning, Medicaid for long-term care, and much more. Our program has no income restrictions, so we encourage you to call our program and speak with an LREP attorney for free. Today we will be going over the Advanced Healthcare Directive. So what is an Advanced Healthcare Directive? This is a legal document that allows you, the principal, to instruct an agent or attorney in fact about your healthcare decisions should you be unable or unwilling to make decisions on your own. This document is referred to by many names, including a living will, an advance directive, or your healthcare power of attorney. It's important to note what this document is not, and it is not a substitute for estate planning. If you have questions about your estate plan, we encourage you to contact our program and get some advice from one of our attorneys. So why do you need an advanced healthcare directive? If you become unwilling or unable to handle your healthcare decisions, you will need someone to make healthcare decisions for you and to help you with your healthcare. Without an advanced healthcare directive, New Mexico law identifies and prioritizes who can make healthcare decisions for you if you become incapacitated. Under the Uniform Healthcare Decisions Act, the person who makes decisions for an incapacitated person is called a surrogate. So the following people, listed in order of priority, may act as a surrogate for you under the Uniform Healthcare Decisions Act. So first, the law will look towards a spouse or significant other. If neither is available, then the law looks toward an adult child. If you have no children, then the law looks towards your parents. If your parents have already passed away, then the law will look towards adult siblings to handle your healthcare matters. And finally, if none of those are available, the law may also look towards a grandparent. If no one else is available from that list, then the law says that an adult who has exhibited special care and concern for you, who is familiar with your personal values, and who is reasonably available to work and act as a surrogate can step up and make those healthcare decisions for you. So you may be wondering who you should choose as an agent under your advanced directive, and we recommend choosing a person as your agent. It should be someone who understands your wishes and whom you can trust to act in accordance with those wishes. You should also choose someone who is reasonably available. We will have clients that call our program and they want to name, say, for example, a son or daughter living out of state as their agent to handle their healthcare decisions. And that's perfectly acceptable. You just want to make sure that they're going to be available when the time comes to handle that day-to-day healthcare decision making. In your advance directive, you can also name successor agents who can take over the responsibility of making healthcare decisions if your primary agent is unable or unwilling to help. There's a lot of discussion about capacity, incapacity, and powers of attorney. So it's important to note with your advance directive that you must have capacity when you sign this document. If you do not have capacity when this document is signed, it is not considered a valid advance directive. So what does capacity mean? Capacity means that you have the ability to understand the nature and consequences of your actions. You have the ability to make decisions, and you have the ability to communicate those decisions to others. Capacity in this situation is often determined by healthcare professionals. So if you execute an advance directive, when does it go into effect? So your advance directive can go into effect under two conditions. It can go into effect when either you grant immediate authority to your agent so they can start making healthcare decisions on your behalf right away, or your advance directive can go into effect when two healthcare professionals determine that you lack the capacity to make your own decisions. New Mexico's Advanced Healthcare Directive form has 3 optional parts, and we'll go over each part in a little bit of detail. The first section is the power of attorney for healthcare. This is where you can name your primary and successor agents. The second section are instructions for your healthcare. These are instructions about your end-of-life decision making, and it used to be referred to as a living will, so you may hear it called by that name as well. The final section of the advance directive is the primary physician designation, where you can designate your primary physician if you so choose. Taking a closer look at these 3 optional sections, the first section is the power of attorney for healthcare, and this section allows you to name an agent to make healthcare decisions for you in the event that you do not have capacity to make those decisions, or you can grant your agent immediate authority to make those healthcare decisions. In the second part of the advance directive, you can provide instructions regarding the types of end-of-life care that you wish to receive. As mentioned before, these instructions are sometimes referred to as a living will. Some instructions that you can give regarding your end-of-life care include whether or not you want to prolong your life, what methods you want used to prolong your life, which include artificial nutrition and hydration, and you can also make known what you want to do with your organs, if you want to be an organ donor or not. Alternatively, if you don't have any strong feelings about your end-of-life care, you can let your agent decide about any or all of these matters when the time comes. In the third part of the advance directive, you can designate your primary physician. This physician would also be one of the 2 healthcare professionals to decide whether or not you have capacity. Because insurance and providers change all of the time, it's important to note that this is an optional section. You do not have to designate a primary physician if you currently don't have one. However, if you do have a primary physician and they have a lot of information about your condition and your treatment history, it's a good idea to name them as your primary physician in your advance directive. Some information about this advanced healthcare directive. It does not need to be witnessed or notarized to be effective in New Mexico. However, if you do a lot of travel in and out of the state, We recommend that you do have this document notarized, and that's because different states have different requirements about the witnessing of an advance directive and the notarization of the advance directive. So long as you have capacity, you can make changes to your advance directive at any time. You can revoke it, you can execute a new one. A copy of your advanced healthcare directive is as good as an original. So it's a good idea to give copies of your advance directive to doctors, your agents named in the document, and family members. Now that you've learned about the advanced healthcare directive, if you want to complete your own advanced healthcare directive, Legal Resources for the Elderly program has a form and informational video to help you complete your advance directive. You can also visit us online to find this form, informational videos, and other resources on other topics. Finally, if you have any questions about the Advanced Healthcare Directive, the form, or any other civil legal issue, we encourage you to contact our program and speak with our attorneys. You can reach us statewide, toll-free, at 1-800-876-6657, or locally at 505-797-6005. Thank you for watching our video.